rise to debate the Public Works Offer Back of and Compensation for Acquired Land Amendment Bill in the name of Te Urarua Flavel. This bill looked to amend the Public Works Act of 1981. It was to ensure that former owners of Maori or general land taken or acquired by the Crown for the purpose of public work are given the first right of refusal to purchase that land back where the Crown no longer requires it for public work for which it was originally taken. Also, that salatium payments could be made for loss of land and loss of opportunities associated with the use of that land where the land was acquired or alienated for public works use for what it was not actually used. And the key here is not actually used. The Local Government and Environment Select Committee has considered this bill. There were 71 submissions and a lot of interest in the bill, which led to some very fascinating discussions. Te Urarua Flavel and the Māori Party acknowledge that although the bill contains issues that should be addressed, the bill in its current form is too far-reaching and broad, and it raises a new set of issues that would be significant for the country. They further acknowledge that the Land Information New Zealand report on the bill recommends that the bill does not proceed. They recommend that it does not proceed because of the retrospective element of the bill, which would negate legitimate past use of the public works land and expose the Crown and local authorities to significant financial costs. They recommend the bill does not proceed because it creates a very restrictive and costly regime for future strategic planning and management of public works and the return of public works land. And they recommend that it does not proceed because the purpose of this bill is already met by current mechanisms for redress for compensation on offerback available through the court system and the Treaty of Waitangi settlement process. The report also notes a series of technical difficulties with the bill. Te Urarua Flavel suggests that while the bill should not proceed, he would like to see either an overall review of the Public Works Act or at least a review of Section 40 that provides a series of issues that he feels any review should contain. These are the issues. The first is the inclusion of the Treaty of Waitangi in the Public Works Act. He would like to see a special review of Section 40 because it fails to acknowledge and address the historical injustices created by the use of the Public Works Act to dispossess Māori of their land. He would like to see salatium payments be made available by the Crown to beneficiaries, and that the Māori Land Court is an appropriate forum to determine these issues. The Local Government and Environment Select Committee reported back to the House that it did not want to proceed with the bill. However, it recommended that when the Public Works Act is reviewed, the issues raised during the consideration of this bill are included in that debate.
I call